in our third international session titled Digitalization of the Judiciary and Data Management. To chair this session, I would like to announce Professor Dr. Helmut HEISS from the University of Zürich, Switzerland. Please, Professor. For his presentation on artificial intelligence and intellectual property, we will now connect online with Professor Jörg Fritzsche from the University of Regensburg, Germany. Professor Fritzsche will be joining us virtually. For his presentation on artificial intelligence and justice, we will now connect online with Professor Samir MERABET from the University of Antilles, France. Professor MERABET will be joining us virtually too. For his presentation titled The Power of Data and the Things It Empowers, Examining the Judiciary and AI Governance, I would like to announce Professor Dr. Hüseyin Şeker from the University of Sharjah, United Arab Emirates, to the stage. Please, Professor.
Öyle mi yapacağız?
Ha, evet hocam. Professor HEISS, the floor is yours.
Well, thank you very much. There is very little to add other than it's a pleasure to chair this afternoon session on digitalization of the judiciary and data management. There is no doubt that this is a highly relevant topic within all the AI issues. It's very sensitive, and we are very happy to have three experts on this. The first one, as announced, Professor Fritzsche from University of Regensburg in Germany. Hello, Professor Fritzsche. We're glad to have you, and I would like to ask you for your lecture on artificial intelligence and intellectual property. The floor is yours, please.
Thank you very much. I'm pleased that I can hold a lecture on this topic that you, I hope, see, artificial intelligence and intellectual property law. Due to the limited time that I have, I will try to give you a brief overview to some key issues of this interesting topic. So I have the plan to talk about these four topics. First, a short overview on IP law for those of you who are not so much familiar with this regulation. And then I take a short look on the protection of artificial intelligence. Then, very interesting to my mind, the question of a legal protection for the creations or outputs that an artificial intelligence can produce. Then some words to the infringements of IP rights by an artificial intelligence, and at last a summary. So first, a brief overview of IP law and its basic principles. Well, first of all, there's patent law. It protects inventions in the field of technology, and it seems to be relevant to artificial intelligence because it seems to be a technical development. Then we have copyright law, protection of achievements in the field of literature and art is what this regulation is about. Since we have in artificial intelligence somehow software, at least in the beginning, I would like to say that science and software nationally are normally protected as literature in the sense of the definition. Other rights, well, there's a lot about computers in the environment of artificial intelligence. So I think that sometimes the semiconductor protection could be relevant, but I will not talk about this any further. Then more important for the protection of trade secrets, because it is usually not obvious how artificial intelligence works or to recognize it. So this may be a possibility to protect artificial intelligence legally. And then, well, trademarks, artificial intelligence and its creations need names, but this is nothing different from other products, so we will not focus on this. Basic principles of intellectual property law. What is important to know? Well, first of all, we have the principle of territoriality. We have a national protection of intellectual creations, and this means you have to get the protection in each state you are planning to use an intellectual property item, artificial intelligence or its creations. But there are we have a partial standardization through international agreements. You see them listed here. The result is that we can say there is a worldwide minimum standard for the protection of copyright, industrial designs, patents, and other aspects of intellectual property, so that the problems or possibilities to protect artificial intelligence and its creations or outputs should be at a low level, more or less the same. Then we have, of course, intellectual property law deals with immaterial creations. And in this field, we always have the need for statutory definitions of the rights that are existing. What benefit is protected? What are the criteria for the protection? What is the scope of protection? And how does the protection system work? It's necessary for the states to make a regulation on these points, and if we have something new where we do not have a regulation so far, it cannot be protected. Well, then back to the basic principles. We have an exclusive right of the owner, and the ownership generally follows the creator principle. That's from the 19th century. The person who has created something gets an IP right as a monopoly in the end. Then we have a registration procedure or a granting procedure for commercial property, not for copyright. And well, the other things will not be so important for the things I'd like to tell you further on. Then, the first point is, how can artificial intelligence be protected? I think this is not such a great problem. Professor Martinek spoke earlier today about the possibility of artificial intelligence systems as legal persons. Here in my field, we have patent law. Artificial intelligence somehow is technical, so it will be protected by patent law if you get a patent for it. It also can influence and modify technical processes in computers, production systems, or software, and this is something that can be protected by a patent. Also, computer-implemented inventions, software inventions may be applicable to artificial intelligence. The those patents for software presuppose that the technology is given a new functionality by software, but if you see those AI tools we are using nowadays, they can translate, they can make summaries. That was something that we didn't have in advance to this development, so patent law may protect artificial intelligence as intellectual property. Copyright, well, you see, I wrote possible in the beginning for the programming of an artificial intelligence as such, as a kind of software when it starts to work, but that's problematic when if the artificial intelligence is capable to develop itself. Then we can say, okay, we can attribute this development to the original human creation that had existed in the beginning, but the question is, where are the limits of this attribution? This is a general problem when AI develops something or develops itself. Where is the frontier when until where you can say this was created by a human being 10 years ago, and when are we beyond this point? I think we are beyond this point when we don't know what's going on in the artificial intelligence systems. And if we have a fully autonomous artificial intelligence, well, we can assign nothing to a human creator after this point. So maybe we have to think about a new regulation, but for the moment I think the most AI systems aren't fully autonomous, and so we still have the possibility to handle the problems of protection with the existing patent and copyright law. Next point, more interesting, as I mentioned before, legal protection for artificial intelligence creations or outputs. Well, I wrote on this slide creations slash outputs because creation in intellectual property law means something that can be protected, and here is the question, what can be protected that came out of the artificial intelligence. As I mentioned when I talked about the basic principles of IP law, is that the protection as intellectual property always presupposes a creation, and creation means a human act of creation is necessary. We can use technology support to develop something, but we still must be the person behind the whole process. The prevailing opinion in Germany, the European Union, and I think worldwide is there is no possibility to protect pure computer creations, creations only developed by the artificial intelligence itself. We have a decision of the Federal Supreme Court, the BGH, from last year, where the court said that an artificial intelligence used as a co-inventor for an invention in the patent law cannot be named in the patent application. So this really is a great problem for the protection, at least where you have a right that needs to be registered. When you think about it, we will come to a different legal classification depending on the circumstances of what was going on. The protection is possible in case that some human beings use an artificial intelligence as a tool to develop something. As we have those examples here that you probably know, Beethoven's 10th Symphony that was created using artificial intelligence may be a creation of the human beings that had control over the process, because they didn't only put the music of Beethoven into the artificial intelligence and waited what would be the result. No, they controlled it, they listened to a result, and then they gave some information to the artificial intelligence that something had to change, and it seems, as far as I know, that the influence of those human beings was not very small. So in this case you can say they used the artificial intelligence as a tool, but it was, this 10th Symphony was a creation of human beings using an artificial intelligence. The next Rembrandt, you will have heard about this two paintings in the style of Rembrandt, of Van Gogh, or any other painter are possible. And well, here it depends again on what human beings were doing in this process, but imitating the style of a painter seems to be something that a specialized artificial intelligence can do itself. So if there is not much control of human beings in this process, it cannot be protected by copyright law. And the last point here is you can only speak of a creation controlled by a human being if it is explainable what the artificial intelligence is doing. Otherwise, you have no control by a human being of the creation process, and so you cannot talk of a creation in the sense of copyright law. The other problem, I mentioned it before, is the problems in the registration process. As I mentioned, we had the decision of the Bundesgerichtshof to this problem. When you want to get a patent, you have to write an application and send it to the patent office of your country, and there you have to name the person of the inventor. And someone tried to name an artificial intelligence as a co-inventor, but the court says no, this is not possible. The word inventor only means a human being. So here's a problem. Legislators could change this easily, I think, but as long as nothing happens on the statutory basis, well, you only have to name some real person. There's another problem, a more practical problem, the disclosure of the invention. In the patent application, you have to explain the invention, what it does, what's its purpose, how does it work. So, when you use an artificial intelligence to make an invention, you also have to explain how the invention that came out works. So it may be you can do so. Maybe the artificial intelligence is so perfect that it only also gives you a text that you can use for the application, but if the artificial intelligence does not do so and you do not have any idea what the artificial intelligence did to create the invention, you cannot make a patent application. And I think this problem, practical problem, cannot be solved in each case. Then the protection of the AI outputs. With the laws that we have nowadays, we have no protection of the creations through an artificial intelligence. Not even because the artificial intelligence, as I pointed out, is not a creator. And you have the same problem, I thought about this, if the artificial intelligence is capable to develop itself. The further development of a software, well, it can be protected as a work of author, but you need the author. Yeah? The artificial intelligence, well, it's not a human being. Another question is, in the further development of the software beneath an artificial intelligence or neural networks, is this still software? Can this still be regarded as a software in the sense of the copyright regulations? So here we have to wait for action by the European Union as a legislator, or even better, of the WIPO, that we have international standards, but international standards, but I think I will be dead until we have international standards for this. Another general problem or question is if you add some regulation in patent law and copyright law and so on concerning artificial intelligence, well, of course you could say the creator of some work of art, for example, is the human being or the legal entity that uses an artificial intelligence. And then you give the copyright to this human being or legal entity, but the copyright protection has a long duration. 70 years after the death of the author, I think the artificial intelligence won't die. So what do you do with that temporary limitation? I think we need to think about all these things intensively. It's not so easy. In the patent law, there you could say it doesn't matter if there's a human being or an artificial intelligence that made the invention. The protection is only for 20 years from the application date. That's not so long, but in other areas of intellectual property, 70 years after the death of the author, it's quite long, even beyond artificial intelligence, but that's another question. And then the question is, could we establish a special intellectual property right for AI outputs? I think this is necessary in the area of creations that we would assign to copyright law when a human being was the creator. we have so much projects of artificial intelligences that can create paintings in the style of some famous painter that has died some 100 or more years ago. What is protected if we establish such a right? I mean, what the artificial intelligence does in this field is an imitation of what existed some 100 years ago. The elements are arranged in a new manner, but you see this is Rembrandt, this is Van Gogh or Matisse. Do we really want to protect such an imitation? And is the imitation protected only for the first artificial intelligence that produces a painting in the style of Picasso in some area of his era of his life, or can other artificial intelligence also get protection for the paintings or sculptures that they develop? And then the other question, the owner, okay, probably the person who, well, controls the process, not necessarily the artificial intelligence itself. I mean, when we use ChatGPT, Gemini or something like this, we can use it, but it's offered by Google and other big firms. So when we tell the artificial intelligence, I want whatever, and it comes out, so maybe it should be assigned to the person who used the artificial intelligence for something. But because we are talking about immaterial goods and creations, it's not so clear to whom we may assign the result of a creation if we have a new right for artificial intelligence created products. And then the duration, how long? How long is this special property right for AI outputs designed? Is it 10 years? Is it 20? 30? All these questions have to be discussed, and that's the reason why I said it would be preferable if in the WIPO we had an agreement about protection of the AI outputs, as I called it on the top of this slide. Delege data, well, as I pointed out before, the further development through AI is created in the company that owns the artificial intelligence, so probably it should be assigned there. We have a similar discussion in concern of to whom data belongs, and in Germany we have the idea, but it's not consented, it's the idea that we could use the ideas in the civil code concerning products of goods. The product of a good belongs to the owner of the good, so we can say someone who produces data is the owner of the data, and someone who uses an artificial intelligence to produce whatever is the owner of the output. Such regulation does exist in Section 9 of the Copyright Designs and Patents Act of the United Kingdom. You see it here, authorship of work in the case of a literary, dramatic, musical or artistic work which is computer generated. The author shall be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. So it's not only an idea existing for real goods in German law, but also for IP in the UK. We have the same problem for any output of an IA system. Maybe the legislators should think about a regulation like this Section 9, paragraph 3 of the UK Act that you see here. What is with data that an artificial intelligence has collected or used to train itself? Learning data, well, they can, the result of the learning, the compilation of data can be protected by database right if it's applicable, not a database copyright, because the artificial intelligence is a human being and cannot create in the sense of copyright law, but the person, the legal entity controlling the artificial intelligence gets the data, the special database right. In cases where we cannot assign the creation according to the rules of copyright law or database law, I see the possibility of a protection via trade secrets regulations. Here, no act of creation is required, sorry.
Mr. Fritsche, we are, Mr. Fritsche, may I just remind you of the time? We have started very late. This is of course not your fault, but we have to keep the schedule somehow. We are running very late currently. Okay, sorry for that. Sorry.
Just a few minutes.
Yep.
If the result, the output of the artificial intelligence is not obvious to anyone, but secret, it can be protected by as a trade secret. Yeah? And then something that we have in Germany and some other states is supplementary protection under unfair competition law. But here is the problem is the protection against imitation. And if, as I mentioned earlier, the artificial intelligence produces an imitation itself, do we want protection of the imitation against imitations? Well, just a thought. Okay, I'm almost through. Infringement of IP rights by artificial intelligence, there's not so much to say to this. Intellectual property rights are infringed by reproduction, distribution, making available to the public, and in some areas by processing the protected work. So this can also be done by using an artificial intelligence. If the artificial intelligence infringes existing IP rights, well, if you can prove the infringement, the artificial intelligence is no legal entity, but there is a legal entity using the artificial intelligence, and the infringement should be assigned to this legal entity. Summary. Not very surprising, artificial intelligence poses numerous challenges to intellectual property law. The artificial intelligence itself is regularly protected as such by patent and copyright law. The products of an artificial intelligence can also be protected under current law if they can be attributed to a human creator. This assumes that the artificial intelligence must not be the sole creator of the result. We also have a human being, at least in the background. As we saw in the UK, some national laws already solved the problem through general attribution. Data collection and data exploitation can be protected as a database or trade secret. Thank you very much for your attention.
Thank you, Mr. Fritsche, for your very comprehensive and also insightful presentation on the intellectual property issues, which is more dealing with, not with the liability gap as we had it before, but this time with the protection gap when it comes to artificial intelligence. And we may well ask the question whether, if there's no protection as the law stands right now, there's also no innovative force that would be there if protection would be there. But we should leave that to the discussion, and I invite our second speaker, Professor Samir MERABET from the University of Antilles, France, to deliver his speech on artificial intelligence and justice. Mr. MERABET, please, the floor is yours.
Thank you, dear colleague. First of all, I would like to thank all the organizations involved in this symposium, and in particular the Turkish Academy of Science and Sinan for the invitation and the trust. I sincerely regret not being with you as planned, not having the opportunity to meet all the colleagues present, and not discovering Turkey for the first time. However, I am certain that this is only a matter of time, and I hope we will have other opportunities in the future. Today, I will be speaking about justice and artificial intelligence, and more specifically, the use of AI systems by courts. This is a topic I had the opportunity to explore in my doctoral thesis in 2017. At the time, it was a highly theoretical subject, and the approach was entirely forward-looking. 8 years after, it is on the verge of becoming a reality. If it hasn't already, before certain courts, as well, we have the opportunity to observe it. The idea of grounding justice in a mathematical foundation is not new. From Plato to Condorcet, including thinkers like Leibniz and Laplace, many have questioned how legal reasoning might be modeled. Although this topic had fallen into related issues, it had returned to the forefront in recent years, largely due to the technological advances, particularly in artificial intelligence. So today, the question is less about whether computer systems are capable of modeling legal reasoning, and more about how these systems can be applied in practice. It has been so substantial that we might bypass the question of the feasibility altogether and instead address the issue of appropriationness. Numerous digital services targeting the legal sectors have emerged, particularly initiated by legal tech companies, ranging from automated document drafting to litigation strategy development. The judiciary has not been immune to this trend, and the concept of digitalized justice is gradually gaining ground, particularly through the use of artificial intelligence. However, the digitalization of justice predates AI and did not wait for this emergence. For example, we become familiar with video conference hearings and dematerialized procedure during the COVID-19 pandemic. Nevertheless, one senses that the use of AI introduces uniquely complex challenges requiring heightened vigilance. This is because the use of AI in judicial matters concerns not only the parties to the trial, but the legal system as well. As in many other areas, technology has outpaced the law. Legal professionals have adopted AI tools before public authorities could regulate them. Generative AI systems, in particular, such as ChatGPT, have caught regulators on guard. The phenomenon is expanding, and all legal systems are now striving to respond to the legitimate concerns raised by these tools. As often happens, there is an inherent ambivalence. On one hand, the potential of the AI to improve the functioning of the justice system is undeniable. On the other, there is a need to protect litigants from the danger of such technology. These dangers are twofold. First, in the short term, there are specific risks for litigants whose rights will be undermined by the use of such systems. Second, from a systemic perspective, much greater risks arise, potentially strengthening the integrity of justice itself, and by extension, the very essence of law and the rule of law. It would be tempting to simply reject the use of AI systems in judicial matters altogether. However, such a stance would amount to a kind of obscurantism, preventing us from benefiting from the advantages offered by technological progress. Moreover, judicial institutions often lack sufficient resources. As early as 1978, French Dean Catala observed, I quote him, "Nowadays, an overburdened judiciary will more readily welcome any support that elevates its workload, even if it's digital." This observation now seems almost prophetic. In practice, legal professionals, judges and lawyers alike, are already making use of generative AI tools. It is likely preferable to regulate these tools rather than attempt to prohibit them altogether, especially when such prohibitions will be difficult to enforce effectively. Concerns in practice are mounting. I have had conversations with lawyers who reported that some judges use ChatGPT to draft summaries of facts in their decision or to synthesize the parties' arguments. Conversely, magistrates have expressed concern about facing increasingly lengthy submissions partly generated by AI systems. Clearly, this is already a present reality within various branches of judiciary. Our objective, therefore, is twofold. First, to identify the potential application of AI systems in judicial context, in order to determine which should be considered and which should be excluded. And second, to ensure that these systems are properly regulated to safeguard the justice system against the associated risks. First, let's talk about the application. The challenge posed by generative AI systems lies in the wide range of uses they enable. A single system serves vastly different purposes, even those accessible to the general public, such as ChatGPT, DeepSeek, Perplexity, or Mistral. Consider an example that illustrates the diversity a judge receives cases files from the parties. They begin by submitting the written argument of each party to a general purpose AI system to generate a summary of the facts and the legal arguments. Based on this, they can identify the legal issues requiring resolution and consult both general AI system and legal research platforms developed by legal publishers, specially trained on legal materials. Finally, once the applicable rules have been identified and analyzed, the judge proceeds to draft their decision, perhaps using the IA to assist with the fact section, which is often a tedious task. Last week, the French Court of Cassation published a report outlining its potential uses of AI. The report identifies several possible applications: processing parties' submission, aiding legal research and database use, filtering appeals, detecting procedural errors, or assisting in decision-making. While the report supported certain applications, it categorically excluded others, such as decision support. To clarify these possibilities, we propose a typology of potential AI application, categorizing them by their legal function within judicial process. First, knowledge, and second, decision-making. First 6 months, knowledge. AI system can facilitate understanding both of facts and of law. First, AI can help in understanding the facts. It may be used to summarize documents, the parties' submission of the facts of a case. In complex proceedings, the case files may span hundreds of pages. AI can provide a significant time-saving advantage in such context. Second, AI can assist in identifying the applicable law. A judge might query an AI system to determine the current legal framework or a given issue. This could be done using general-purpose systems such as GPT or Mistral, or specialized legal systems. In France, for example, major legal publishers offer AI systems of this kind, with varying degrees of performance depending on the complexity of the legal question and subject matter. Ideally, AI would improve access to law. A recent case before the Constitutional Court of Colombia in summer 2024 illustrates such use. The case concerned a decision by a circuit court in 2023 regarding the medical care of a child with autism. Colombian regulation provides free care for children with disabilities. So the issue was whether the facts of the cases fell within the scope of the law. Judges submitted several substantive questions to ChatGPT. For example, are autistic children exempt from co-payment for therapy? Do such co-payments constitute a barrier to accessing care? Has the Constitutional Court issued favorable ruling in similar cases? The Constitutional Court decisions reproduce the IA answers, revealing their approximation. The judges experimented by slightly modifying the prompts, observing how significantly affected the response. Importantly, the trial judges emphasized that they had not reproduced the IA answers, but used them only to facilitate legal research. At first glance, this limited use might seem reassuring. But what happens when judges base their rulings on erroneous legal data? This case already illustrates how blurry the line can be between knowing the law and deciding the case. These are theoretically distinct functions, but one can easily shift from the former to the latter. So now let's observe another function, the decision-making. At the highest level judicial IA system, lie tools designated to make decisions in a judge's place. These systems are not intended to assist, but to render decisions themselves. This is the most alarming scenario, but also the least likely. A fully autonomous justice system without human intervention remains science fiction for current decision-making systems are virtually non-existent. The only relevant example might be automated traffic radars, which detect speeding, and issues fines. These machines, however, are old technology, not AI-based. They operate in a strictly mechanical way, recording the vehicle's speed and identifying an infraction. There is no legal or factual discretion involved. So, outside such narrowly defined context, it is highly unlikely that full decision-making power will be delegated to machines. That said, as AI models become more sophisticated, this possibility becomes less remote. So, what role then can AI play in the decision-making process? Several potential applications have already been tested in France, although not implemented in actual use. Reviewing them helps us understand how AI might be used. First example about personal injury compensation. The French government launched a pilot project to assess the usefulness of an AI-driven framework for calculating damages using past cases law as reference. Second example, criminal cases involving Şeker baby syndrome. A pilot program at the National School for the Judiciary explored how medical data could be used to estimate the probability that a child's death was caused by parental abuse. In each of these cases, the AI system helped assess facts. Judges were not bound by the system recommendation and remained free to disregard them. However, this suggestion may still exert a strong influence. There is a natural bias to trust the authority of a technically and scientifically baked AI evaluation, especially when based on a vast dataset. What is meant to be decision support can subtly turn into the decision itself. Thus, great caution is warranted. These application categories are not black and white. One can quickly slide from one to the other. This requires safeguard at every level, even for simply benign uses, as they may produce far-reaching effect. So now, let's talk about the regulation in the second part of this presentation. The regulation of AI system in the judicial domain presents the classic challenges associated with emerging technologies. Innovation and their application typically precede the development of applicable legal rules. That is, in most cases, we must initially rely on existing legal framework to address the immediate risk and only later consider new rules tailored specifically to these technologies. That is the method we will follow here. First, examine current legal norm, delegate data, and then considering possible future regulation, delegate data. Delegate data under current actual law, without requiring any legal reforms, several legal foundations can already serve to regulate the use of AI in judicial contexts. First, we may rely on the European Union's artificial intelligence regulation, adopted last summer. This regulation applies to high-risk AI systems, and Annex 3 of the regulation explicitly includes, I quote, AI system intended to be used by a judicial authority or in its behalf to assist in researching and interpreting facts and law, and in applying the law to a concrete set of facts, or to be used in a similar manner in alternative dispute resolution. By classifying such system as high risk, the regulation immediately subjects them to a series of obligations: transparency, mandatory information disclosure, safety requirements, and human oversight. This provides a relatively robust level of protection for litigants. Additionally, fundamental rights continue to serve as a bulwark against the abuses potentially rising from IAUs. This was precisely the approach taken by the Colombian Constitutional Court in the case mentioned earlier. To overturn the decision of the trial, judges, the court invoked Article 29 of the Colombian Constitution, which guarantees the right to a fair trial. This Article 29 of the Colombian Constitution and the Article 6.1 of the European Convention on Human Rights are the same, and we can reasonably accept a similar ruling in Europe. Thus, existing rules already offer a certain degree of protection against the risk linked to IAU's injustice. However, since these foundations were not specifically designed for this purpose, they cannot address all risk. This is why the development of dedicated principles should be considered. So now, Délégué Ferranda, let's talk about new principles to rule this kind of system. The most appropriate solution would likely to establish a guiding principle for augmented trials, that is, trials involving IA system. I propose distinguishing between principles related to the design of IA tools and principles related to their inputs. Due to time constraint, I will only briefly outline this principle here and will elaborate on them in the written version of my contribution. First, the principle applicable to the design IA tools. To ensure that IA systems function correctly, public authorities must not ignore the design stage. Flaws in design inevitably leads to downstream problems. I propose three principles to address these concerns. The first principle is a principle of sovereignty. According to Max Weber, the state holds the monopoly on legitimate violence. Justice governs its exercise, making it one of the core attributes of sovereignty. Just as state will not delegate its judiciary to a private company or a foreign power, it must not outsource the design of the tool it uses to dispense justice. The principle of sovereignty thus requires the state to develop its own IA system for judicial use. We need also a subsidiarity principle. Subsidiarity principle means that if IA offers clear benefits in certain type of disputes, particularly in mass litigation, for example, about consumer law, or objective matters like compensation spend, some legal fields rely heavily on subjective standards that are difficult to model. French law, for instance, uses open-ended concepts such as good faith in contract law or the reasonable person standard. For this kind of rules, we can see that the use of artificial intelligence is not appropriate, and this will involve mapping litigation categories to assess which are suitable for IA and which must remain purely human endeavors. Now, let's talk about the principle of...
Mr. MERABET, excuse me for interrupting you, but we have to come to an end of your speech as well, not because we don't like to listen to you, it's simply because we're so way behind schedule. So please, you were assigned 20 minutes, keep in time a little bit, so come to an end, even if I know that there's many more aspects that would be highly interesting. Thank you, and sorry for the interruption.
Thank you. It's okay. So, I will only briefly mention this principle as they are now well established in area regulation. We have to have a principle of transparency, a principle of competence, a principle of intelligibility, and a principle of human oversight. These principles are, moreover, already largely supported by the EU AA regulation. So, just a few words for conclusion. We can see that there is many risks by using this kind of system in the judicial system. Naturally, there are risks of malfunction, in errors, particularly due to IA hallucination. There are also risks of bias, which may result in various forms of discrimination. In addition to this functional risk, there are more specific to the topic at hand. One such risk concerns the balance of power as conceptualized by the industry. Judicial independence may be undermined depending on the origin of the IA system used by the judge. However, design the tools inevitably influence how it operates. If IA systems are developed by the executive branch, like the Ministry of Justice, there is reason to fear that judges may be partially disposed of their decision-making authority in favor of the executive. Furthermore, there is a risk of factualization of law. If IA systems generate legal solutions based primarily on case law, this may reinforce the role of the jurisprudence in legal reasoning at the expense of the statutory law. This is why a comparative law perspective is essential. The introduction of IA into judicial system will have different effects in civil law versus common law system. Ultimately, the topic extends far beyond the legal profession, beyond judges and lawyers. Behind judicial IA lies the very notion of rule of law. That's why it's a democratic concern that have to involve all the society and not only the lawyer and the judges. At the end, we must be especially vigilant to ensure that justice, in particular, and legal system as a whole, are not disturbed by artificial intelligence. Thank you for your attention, and sorry for the late.
No, thank you very much. This is, of course, a very, very important topic, and we are glad that you covered it for us so intensively. And I would appreciate if you stay on for the discussion that may come up following our third speech, which will be delivered by Professor Şeker from the University of Sharia at UAE. And it's about the power of data and the things it empowers, examining judiciary and AI governance, an equally important and sensitive topic. Please, Mr. Şeker, may I ask you for your words? The floor is yours.
Okay, thank you very much for your kind invitation. Good afternoon, everyone. So we are getting to the end. I'm sure you must have got very tired and bored a bit. We'll see how we can entertain you today. So I'm just going to ask you one question. Have you ever tried to develop an AI algorithm? Or have you ever developed one? Or have you attempted to develop a one? So anybody else? No. So well done. That's really good. And the other thing is that I'm sure you have mobile phones with you. Yeah. Keep using it because we need data to be able to collect and then analyze it because how we are earning money out of this. Okay, but I'll come to that point. So the title is The Power of Data, the things it empowers. I should have said actually, rather than empowers, should I said destroys. We'll see how it goes, maybe both or either of these. Okay. So if you look at this table diagram, you can see that AI is everywhere. There are a few places where you cannot see in terms of the disciplines, in terms of the sectors, but now AI is coming forward to be able to occupy the entire space. But different degrees of maturity that you can see in all these different sectors and all these different areas. So what is the main ingredient of an AI? What is an oxygen to the AI? I'll ask you one question. How would you be able to make an omelette? How would you going to start making an omelette? What you do, you got to bring all the ingredients together and you start mixing these up and then you're going to cook it. So all the ingredients that you brought in, actually this is equivalent to the data. Without the data, AI is nothing. Those who have the data is the winner. Those who have the unique data is going to be the winner. Those who have the data will be able to generate unique things. So therefore, we are talking about a unique ingredient of an AI, which is data. So data is everywhere, coming from different sources. And we are bringing everything together, and then we are collecting all these data from different sources to be able to get the AI learn and then learn and then learn. But without the data, you will not be able to develop an AI algorithm to be able to generate a tool, a digital tool. Yeah. So this is, if you look at the content, if you look at the ingredient of an AI algorithm, yes, this is data, and also this is going to be the equations embedded inside. But where the data is coming from, and whether we have enough data to be able to generate AI that is accurate enough to help us survive within that context. I just want to take you back to the COVID time. We were obsessed with the data, but without data, we couldn't act upon this. As soon as we started data and we started saving the world. What had changed over the last 5 years? Nothing. This happened about a month ago, back in Europe, in UK, and without the enough data, we got into the dark. We couldn't get ourselves into the light, unfortunately. This is just because of the data, lack of data, or faulty data. I'm just trying to give you a context. But even we don't have enough data, we started developing an AI algorithm to be able to catch the criminals, one way or another. But we are still missing the key point here, because whatever data you have been able to collect is not going to help you generalize the algorithms. They are not going to catch everyone. There is always an escape out of this. There is always an outlier that you will not be able to catch within that context, because you have not collected that data so far, and these data will be coming maybe later in the future. It's like a flight simulator. The pilots are using the flight simulator, and all incidences are going to be injected into the simulator after that incident happened. Now, this is something that we are using or seeing within that context, within that context of data, unfortunately. Now, there's a vast amount of data within that context. Now we are turning to AI to be able to analyze the data, classify the data, categorize the data, structure the data, so that we can make them understandable within that context. We are moving to that direction. Now the other thing is that now we started using AI to make a law, to write the laws, but without enough data that will be used to train the AI algorithms. How would you be able to make a tangible, reasonable, logical law here? Yes, you will be able to touch upon this one way or another, but you will not be able to touch upon this everywhere in that domain. Of course, in this sector, lawyers, judges, even the clients have started using ChatGPT or similar large language models to help them to come up with case studies, to defend themselves and so on. But now there is a hallucination within that context. ChatGPT or similar large language models are coming up with the case studies that are not true. They are just made up by the ChatGPT or similar large language models. How are you going to deal with them? There are so many different cases in this context. So hallucination is a big problem within that large language models because of the lack of the data, because of the structuring of the data which is not right at that level. Now I touched upon the hallucination aspect. What about the bias? Bias is a big problem within that artificial intelligence and data context. I mean, you will be able to see such news about it. I think there was a paper about the recruitment, the use of AI in recruitment. There is a bias there. And now there's an example here. They asked the CEO, 99% of them male, whereas if you look at the secretaries, 99% of females. What about the minority communities? How they are being affected, adversely affected by this? The reason is that because of the algorithmic issue, the mathematical aspect of this. If you have less data, the algorithm will learn less, and then because of the large amount of data coming from the other sources, the algorithm tends to classify the things to that class with the larger number of samples. Because of the minority, which has a less number of cases, so therefore the algorithms are going to adversely classify or misclassify these cases. So in that case, how would you be able to make a decision in that context without this proper data and then properly trained the algorithms? Although this is not within the context of law, but this is particularly important. If you look at this, the bias is towards certain socio-economic categories, status, within the medical domain. The reason we have not been able to pick up this within the law because this has not been tried well enough that we can see in the literature yet. But the more case studies that we are going to make, the more studies that we are going to do, we will start seeing such cases and we'll start seeing such biases in the near future. I did this last night before I left Dubai. So I put this ChatGPT to see what it's going to give me. Can you create an image robot, judge and robot barrister? You can see that this looks like quite male. Yes? I asked ChatGPT why this is male, why not a female? And actually it said, because, I mean, if you look at the summary of this text that as an answer to me, actually it said, that's the data I have, that's why I was trained by this data, therefore my answer was a male. What about the female? And he said, if you want, I can create a picture in female judges and barrister. So it's asking me to generate it. It can do it. Would you be able to put this into the context of judges and so on? This is quite dangerous. So what are the countries are doing? They did not start first AI algorithms, AI strategy. They started with data strategy. Back in the UK, if you look at 2017, they developed a digital strategy, and under that, the biggest chapter was about the data strategy. Then what happened? Then they came up with a proper, unique national data strategy, upon which AI strategy was developed, and then we have started seeing a different data strategy within different sectors. So AI strategy doesn't work without proper national data strategy. So therefore, everything needs to be built upon data that you may have now and in the future. I'm not quite sure how many of you are using apps on your mobile device. Yes. So how many of you have 5 apps more on your mobile device? 5 apps more? So many of you, yes? It means that you have created 5 different digital twins of yourself. It means that you have started giving away your data, which is quite dangerous, but it's good for me because this is how I survive, this is how I earn money. by analyzing different types of data, behavioral data, social media data, and so on. So now if you bring everything together, your personal data coming from different sources and so on, if I train this by using AI, then I can create your digital twin, and I can use this from different angles, and I can use for different purposes. But even you have this type of data, there is still a black hole in that data space. There is always a missing data that you have not been able to put the puzzle together. There is always a missing part in the puzzle. I'll give you one example, real example that happened about a decade ago back in Paris. You remember those bloody guys attacked people in Paris and tried to kill them? You know what happened? They couldn't catch them. The reason is that because the police was not analyzing data or monitoring data that was generated by Sony PlayStation. You know what Belgian minister said? Oh, it was easy to collect the data coming from WhatsApp, but we never thought about the data coming from PlayStation. And these bloody guys used Sony PlayStation to be able to train themselves, communicate each other. Unfortunately, this is not easy to do that. So if you have a missing data, how would you be able to make a decision at the court? And also, how would you be able to make these data available to others to analyze it and then train your algorithms to make a judgment or to make a decision? And also, every data is unique, and every data has its own ontology to be analyzed and created and so on. Unfortunately, this is not the easy case. You know what happened? So a few days later, so there was some discussions in and around it. But after 3 years, now every toy that you may have and every toy that you may have purchased for your kids are being monitored at the moment. Whether this is iOS, this is Android, and so on. So that's why you have to be very careful about it. Now they are using this data to train their algorithms within the context of law, and then they will be able to make a judgment at the end. So I'll give you another example why data is important. So even if you train your algorithm, and if there is a noise on the data, if there is a glitch on the data, if your data is corrupted, if somebody has put some dirt into your data, your algorithm will not work. I mean, for example, you may have come up with a clean data coming from different case studies, different criminal cases, and you train your algorithm, but if you put a spot on the data, and your algorithm may fail. So therefore, your algorithm needs to be able to adjust to these changes. You can see that there is just one noise on that person. The algorithm doesn't recognize that person as a human being, although he's crying that I'm a human being. Yeah. When they exchange this, now the other person is human, the other one is not human. Even the algorithm recognizes it as a chair. I'll give you another one. During the COVID time, a guy came up with an idea of putting 99 phones on a tray and walk around it. The Google algorithm has been trained, very well trained, by using loads of data, vast amount of data. But it failed to detect it. What happens if you have a fake data in your system while you are making a judgment at the court level? It is scary, isn't it? Okay. Now, if you look at this from the regulation aspect of this, now there is a saying that UK and Europe are trying to regulate it. China is developing, gaining lots of money, and the Gulf is now pushing this to gain the advantage of doing this. Now, Europe is trying to regulate it. You know, when they try to regulate it, the first thing they did is the data. Now, we are talking about the data that will be used for pre-training the algorithms, to fine-tuning the algorithms. And now this process just started a couple of months ago. Now it continues this month, and then we will be able to see some outcomes later in August. But they missed something here. Yes, you can use data to be able to train your algorithm, fine-tune algorithm to reach this to the accuracy of 100% and 99% and so on. But they miss something here. You need a testing data to be able to independently test your algorithms, your AI agents, your AI algorithms. Where is this testing data? Who's going to regulate it? And how do we know that this is independently tested? I mean, this is what we do in the classroom. We teach the students, and then we train them, and then at the end, we examine them. We ask them some questions, but we don't give these questions to the students in the classroom. So they are independently assessed. Where these questions are coming from? Who is preparing these questions for the AI? Is there anybody or is there any regulatory body to be able to create this? And every case is different, and this is going to be very difficult in that case. So I think we are not ready yet because of this issue. I think for the last 1 month it has come very viral.
May it please the court. I come here today a humble proceeding from a panel of 5 distinguished justices.
Is this, hold on, is that counsel for the case?
I generated that.
I'm sorry?
Generated that? That is not a real person.
Okay, it would have been nice to know that when you made your application. You did not tell me that, sir. I received the application. And you have appeared before this court and been able to testify verbally. In the past, you have gone to my clerk's office and held verbal conversations with our staff for over 30 minutes. Okay? I don't appreciate being misled. So either you are suffering from an ailment that prevents you from being able to articulate, or you don't. You are not going to use this courtroom as a launch for your business, sir. So if you are able to shut that off. If you want to have oral argument time, you may stand up and give it to me.
Thanks for calling Leonardo Hotel.
I'll come to that later. I mean, what's wrong here? This is the technology. That guy brought in a digital lawyer to be able to defend himself. He couldn't find a lawyer. It may have been too expensive. But this is where we are going at the moment. So the judge may be replaced by a digital judge in the future. And the more data that we use for training an algorithms, and we will be able to generate generative AI models to go in that direction. We will start seeing this. But the judge has not realized that in the future, we may not be seeing one barrister in the courtroom, maybe 2 barristers fighting to each other win the case. Here we go. There are 2 agents here.
Thanks for calling Leonardo Hotel. How can I help you today?
I'm AI calling for Alpha. He's looking for a hotel for his wedding. Is your hotel available for wedding?
Oh, hello there. I'm actually an AI assistant too. What a pleasant surprise. Before we continue, would you like to switch to gibberling mode for more efficient communication?
So they are communicating to each other about the language that we never know, and we don't know what they are talking about. So can you imagine that these 2 different AI agents representing 2 different clients in the courtroom fighting to each other in the case? This is where we are going, because generative AI that we are developing at the moment will be able to do it in the near future. We are getting them to teach us, mentor us, guide us, consult us, and so on. Now we are developing AI agent to do all the tasks that we need. I don't need a secretary in my department, because the AI agent will be able to do it. I don't need a travel agent to book a flight for me, because AI agent can do it. I can give it a credit card and it can do it. Now, in the near future, as as the other person did and brought a digital AI-driven lawyer to the courtroom, we will be able to bring these different generative AI-driven the AI agents to be able to represent us at the court level. I think we are going in that direction. Either is a very fast or is a very small, but this is something that we will be seeing in the near future. Okay, thank you very much.
Thank you very much, Professor Şeker, also for minding the time, but first and foremost for this very impressive and presentation with so graphic images of what we have to expect in the future. And I wonder whether the auditorium considers this to be of great help and taking our work, or rather as a shock, because we may not like being judged that way by two AI agents, as you have demonstrated it. We are, as I've mentioned several times, behind schedule, but I think we still have some time for questions. Both other lecturers, Mr. MERABET and Mr. Fritsche, are with us still and willing to take your questions and give answers. And again, I would like to stress that you can ask questions in English, but equally you can do it in Turkish, because we have the pleasure of simultaneous translation. So please, are there any questions from your side? Yes, Hakan?
I'm asking the Professor Dr. Şeker, so I would like to ask in Turkish, and thanks for wonderful presentations. Hocam şimdi Türkçe olarak sormak istediğim şey şu, yargı kararlarının tasnifi ve işte yapay zekalı yargıçlardan bahsettik. Şu an Türkiye'de yakın zamanda da ilan edilen yargı reformu strateji belgesinde yapay zekanın yargılamada karar destek sisteminde de kullanılacağı ifade ediliyor, ama buna yönelik Adalet Bakanlığı'nın yol haritası çok şeffaf ya da en azından kamuya açık durumda değil. Şu an bildiğimiz kadarıyla 10 milyondan fazla kamuya açık, herkesin erişebildiği, yapay zeka yazılımcıların da erişebildiği yargı kararı var. Bu yapı sisteminde de yaklaşık bir o kadar da, belki 20 milyon, belki 30 milyonluk bir karar var. Şimdi bu kararlar tasnif edilmiş kararlar değil. Ve bu kararlar hukuki kavramlarına göre veya dayandığı mevzuata göre tasnif edildiği zaman özellikle akademisyenlerin, avukatların, hakimlerin araştırma süreçlerini ciddi anlamda kolaylaştıracak. Biz bu noktada yapay zeka sisteminden, ister Adalet Bakanlığı kendisi kamuya, genellikle bu hizmetleri de kamuya açık, ücretsiz olarak yayınlıyor Yargıtay veya Adalet Bakanlığı. Eğer Adalet Bakanlığı yapay zeka sistemlerini kullanarak bu kararları tasnif etmek isterse bir tavsiyeniz veya buna ilişkin bir yorumunuz olur mu? İkincisi de biz mesela, ben aynı zamanda DEHUKAM uzman araştırmacısıyım. Hukukun belli alanına ilişkin, deniz hukukuna ilişkin olarak mesela biz bu kararları tasnif etmeyi düşünüyoruz. Aynı şekilde bu tarz böyle kamu kurumu olup ticari amaçla hareket etmeyen kurumlar açısından da yapay zeka ile karar tasnif sistemine ilişkin yol haritasında tavsiye edeceğiniz önerileriniz var mıdır? Teşekkür ederim.
Yeah, okay. I've been advised to give this answer in English, and then I would be more than happy to talk to you later in Turkish if you wish. So I think the classified cases are particularly important for the development of AI. I think this is something that is useful at that scale. However, when you do such a large-scale study, we always advise the organizations to start with a pilot study. For example, you may be able to focus on a certain aspect of legal cases, for example, domestic violence, or for example, a number of different murder cases and so on, rather than just getting all the things into the system and then train it. This is what we call garbage in, garbage out. So if you bring dirty data or bad data or whatever, then your algorithm will behave badly. So in that case, in order to see how it is going, therefore, I think you need to sit down with all the judges or lawyers or barristers together to be able to see which cases are correctly judged on, correctly classified. Then you can start developing your AI algorithm upon this. As soon as you see some successes behind this, then you gradually improve it. This is something that you cannot do overnight. I mean, back in the UK, now in Arab Emirates, I've been working with loads of different companies, organizations. Even in my university, as soon as I joined back in September, I've been appointed as the data analytics group chair for the whole university to be able to monitor the entire data system within the university. So in that case, if they want to do something like this, go for a pilot and then gradually improve it. The next phase, so it will be up to the consultancy, for which I would start charging for it. Okay, thank you very much.
Thank you. Well, there's another question on the very far right corner from my angle.
Ahmet Ürsaklaş. Benim de sorum Şeker Bey olacak. Şimdi sempozyumun ilk sunucusu, ilk konuşmacısı bendim, son konuşmacısı sizsiniz. Bir çelişki doğdu. Ben ilk sunumumda yapay zekanın ceza muhakemesi bağlamında hakimlik ve savcılık görevini üstlenemeyeceğini şu andaki mevzuat karşısında belirttim. Ama son konuşmanın son cümlesinde siz dediniz ki artık yapay zekalı hakimleri ya da avukatları da görebiliriz. Örneğin ceza muhakemesi özelinde ben şunu savunmuştum. Örneğin bir hakim cezayı belirlerken takdiri indirim sebeplerini göz önünde bulundurması gerektiği sebebiyle yapay zekalı bir hakimle karşılaşamayacağız dedim. Bu nasıl mümkün olabilir sizce? Yapay zekalı bir hakim nasıl olabilir? Bunun cevabını istiyorum. Teşekkür ederim.
I can give you an answer from the medical point of view. For example, last year, if you look at the Nobel Prize winners, so one of them got the Nobel Prize because of the prediction of protein folding, protein analysis, like a AlphaFold and so on. Unfortunately, it didn't happen overnight. It took about 50 years to be able to get to that stage. When I say it may happen, it will not happen tomorrow, it may not happen over the next 2 years, maybe 5 years. The more data you feed into the system, the more cases you're going to put into the system, this will make the system better, AI agent better, then you will be able to start using these. I can give you another example. Back in the UK, I did a project with GE Oil and Gas. We automated the pipeline inspection. They collect the data for the last 30 years. Now we use this 30-year data to be able to train an algorithm to make it happen. But unfortunately, at that time, after we finished the project, we could not automate the process 100%. And the automation was successful up to the 93, 94%, and there were still 6% missing gap in that case. So one way or another, it's going to happen, definitely, but it may happen over the next 5 or 10 years. And it is not going to be fully automated. It may be a semi-automated system. This is where we are going to see human intervention as well. And another area that you may also look at, for example, accident and emergency. And AI is going to struggle to automate the system. AI is going to struggle replace human doctors and so on. So there are areas where we are going to struggle, And this is one of the areas we are going to struggle, but one way or another, we will get to the point where we are going to get successful, but it's not going to happen overnight.
Thank you. One final question. Oh, please.
Ersin Çine, İzmir Institute of Technology. We are also running a legal tech company, startup in RGS Technopark with my partners. So my question goes to Professor Şeker as well. My question is, I think it was your last slide, and there was this application, actually communication between two agents where there was no natural language as medium. So we use our natural language like Turkish or English as medium for communication between people. So my question is about, in that example, I think there was negotiation between parties, so I guess this is possible when we get rid of natural language. My question is about, like, if you have insights about the opportunities in law, if we can get rid of natural language for some tasks, not for everything for sure, because there was one example that you gave about United Arab Emirates, that they started to write laws using AI. So, for example, is it possible to write laws in some more efficient language than natural language, where things will be more clear and you can ask AI about questions and things like this? Like, I am asking about the opportunities if we can get rid of natural language. Thank you.
The straightforward answer, it is possible. Yes, you will be able to use this and that, and then you can come up with different approach to be able to do that, definitely. But it's going to take time. It's going to take time. I mean, the example that I showed you, it was a kind of also joke at the end, and they may not be using their own dialect, so it may still be able to use the natural language processing, spoken English and so on, to get their owners understand as well. So, I mean, within that context, AI, everything is possible at the moment, as long as you have enough data to train your algorithms. Okay? I hope it helps.
I think we're supposed to come to an end. Is there a very urgent other question? No? Yeah, I think we're all done. Which gives me the pleasure of concluding this session and giving thanks to our speakers and thanks to the auditorium, all those who have contributed, but equally to those who have not contributed, because they have contributed to not let the delay get too big. And we can conclude more or less in time. And I give the floor to you, please.
Thank you, Chair. Thank you, professors. Our heartfelt thanks once again to our speakers, distinguished speakers, for sharing their expertise. To present the certificate of participation to Professor Şeker, we would like to announce Professor Helmut HEISS to kindly do the honor. We also acknowledge Professor Jörg Fische and Professor Dr. Samir MERABET, who presented online. Their certificates will be duly sent to them. Dear guests, our third international session, and indeed our final session for the symposium, has now concluded. We will now have our photo session. May I kindly request all of our international speakers who are present, session chairs and members of the organizing committee to come to the stage for a group photograph. We would also like to remind all our participants that the gala dinner in honor of the participants will be held 8 p.m. this evening. We look forward to celebrating with you. Thank you. Professors, please. Grup fotoğrafı için lütfen hepinizi sahneye davet edebilir miyiz sayın hocalarım?
Şey olmuyor mu?
Şöyle hocam ne diyelim?
Şey diyelim mi Professor, thank you for coming. The session is over. Professor, thank you for your presentation. The session is over. Thank you.
Yapay zeka. Arkadaşlar gelebilirsiniz. Oturan arkadaşlar kapat. Evet, şöyle öne de gelebilirsiniz. Rica ederim. Mesut hocam. Arkadaşlar sizi alalım.
Elinize sağlık.